Thank you, Michael. Thank you for the invitation. I must say it's a great honor for me to give you some insight on what we will be facing starting from the end of this month. As opposed to what Stefania covered just a few minutes ago, I will take I will take a bird's eye view on where we are, and I will be dealing with very general issues. I think this will give us some sort of resume of how the proceedings have evolved and where we are in a position to compare the changes and appreciate the changes. And obviously, we will anticipate what the ECJ will be, how the ECJ will be interpreting the new regulation. So, in few words, I think I will tell you a little bit about what are the basic changes between the regulation which is still in force and the recast. Then I will deal with the subject of the scope of the application and what is in the title of my presentation, that is pre-insolvency proceedings and hybrid proceedings, and concentrate a little bit on these forms of preventive proceedings. And obviously, some food for thought at the end, and it's a question to address to all of you. Basically, well, where we will end up with the new regulation. Obviously, not only the regulation, because I take the view that the world has become much more complex, and the regulation shows that. But on the other hand, simplicity should be the name of the game, because the law should be applied by everyone and not just by the experts. So, to introduce the subject, I think it's been done already to a lot of extent. I just want to refer back to, just to show you where we are to appreciate the changes. I want to go back to the Virgos and Schmidt report of 1996, and the Virgos-Schmidt report which was a sort of Bible, I think, to many, at least to me, on the interpretation of the regulation. In one place stated that the provisions of the regulation must apply to insolvency proceedings which will fall into the convention, that such proceedings are only based on debtor's insolvency. By insolvency at the time, it was understood, obviously, that it's a liquidation insolvency, or there is an arrangement accepted during the insolvency proceedings aimed at the liquidation of the assets. Nonetheless, as we have seen in practice, there were some provisions in the annex to the regulation, and the member states have introduced proceedings which were typically not liquidation proceedings, but were aimed at rescue. And I think with the change with the recast, we are very clear now that these are covered, and I will follow that subject in a second. And obviously, so to put everyone in the perspective, of course, we have this new recast. We have the proposal of the directive, which will be, I think, discussed tomorrow. And as many of you know, this is just a proposal, which means that, as far as I know, and I have learned that 1 month ago, that there is still work on it by the Commission, by the Parliament. They are going through all of the provisions one by one. They have not reached a stage where they are close to an end. It's the opposite, in fact. There are some controversial issues being touched upon, like the concept of intercreditor cramdown, intergroup cramdown. So I think we should all have in the back of our minds that these are proposals, these are not final concepts, although one may expect that in one way or another they will become a directive. And clearly, to appreciate the change during the past 20 or more years, one just need to look at the provisions, at the laws of the member states, and I would assume, because I just only know in relation to some of the jurisdictions, that all of the states, or the majority of the states, have already revised the national laws to account for preventive proceedings, for rescue proceedings. So in a way, it will make it easier to implement, to use in practice the regulation. So one of the basic changes which have been instated is that the following Article 1, which deals with the scope, the regulation deals also with pre-insolvency proceedings. Of course, the term pre-insolvency is a common term. It has no definition per se. It basically implies that there's a certain type of proceedings which is regulated by national law, which should come or should be applied before or instead rather than a liquidation proceeding, because that is the aim of the proceeding, to rescue, and there are other aims which need to be reached. So the name pre-insolvency may in fact be a wrong term used, because they are not to be applied before insolvency. In fact, it's the opposite. Liquidation insolvency is to be avoided, so it should be really the term preventive proceedings, which is I think encompasses all of the elements of these proceedings. The model, or sort of the situation related with the 1346 regulation is followed in the recast. Denmark is not covered, and of course we know about Brexit, and we'll learn more about it tomorrow. And if you want, from a practical perspective, to appreciate the number of changes, it's good to look at Annex D of the recast. There's a table which shows which article corresponds to which, and you can see to what extent how many new articles have been introduced, in fact. So what are the most important changes which have been introduced? And of course, it's a subjective view on the subject. Well, we have the concept of COMI has been retained. I think it has been made stronger by having provisions related to a COMI move and COMI tourism. We all know that there were companies or advisors who would shift COMI from one place to another if required, and they would follow ECJ rulings on that to make it bulletproof. So we have the concept of good and bad tourism, and to some extent, and then I'm saying to some extent, I think the regulation is dealing with this subject by the presumptions introduced for taking the old COMI and keeping old COMI if it has not been moved for 3 or 6 months. There's also a procedural element, I think, added, where in case of doubt there need to be additional evidence submitted when international jurisdiction, when jurisdiction is sought, so that COMI is indeed where it is perceived to be by creditors or by stakeholders or by third parties. And this is again to combat at a certain period of time, I think, a process where COMI has been, as in one UK court hearing I recall said, COMI was established on the thinnest of margins, whatever that means in English, thinnest of margins. So to me it means that you could have decided that COMI is here or there. So in order to avoid this, I think we have new provisions on COMI. And of course, this is one of the key elements of the new regulation, that we have these preventive proceedings. Another important element of the new regulation is the fact that at last, I would say, we have the ability to coordinate proceedings, and coordinate proceedings not only when one talks about main and secondary proceedings, which should be coordinated and where the general aims of the main proceeding should be followed, because after all we are dealing with one debtor. And secondly, I think it's a stage in the development where you have coordination of proceedings if one deals with number of entities which may be part of a group or a holding of companies, of entities, and to this end there is reference to the definition or to the terminology used in the accounting law. So coordination, or I would even use the term synchronization of proceedings main with secondary and proceedings within a group, that's going to be made much easier, and I think the business approach should prevail over what the legal approach the lawyers would take, because at the end of the day it's a question of sustaining the business, to have it to continue, and also to obtain to having maximum return to creditors, and also safeguarding the interest of those creditors who do not have to be involved in these preventive proceedings. Another issue which is worth mentioning is the evolution of the insolvency practitioner, or some call him, her, or the entity which provides these services, the insolvency office holder. From my limited experience, I can see that the role of the insolvency practitioners who are either assisting the debtor in preparation of insolvency plans or restructuring plans, or are in fact administering the business when the debtor loses the possession, is no longer in possession, that is really on the rise. And although this is not a discussion related to market trends, but clearly the presence of IPs is really visible, and it's visible also in the provisions of national laws. The profession is becoming regulated. So I think clearly with the application of the new recast, the role of the IPs is clearly on the rise, and they will have a decisive role in reaching a success of any preventive proceedings. Last but not least of the elements which I see as key in the regulation is the question of information and access to the information. And we know of a number of cases where, due to lack of information, creditors' rights were not applied because, for example, no one knew in another member state that proceedings were opened in the first place. So if you do not know that proceedings are opened, how can you challenge under the lex fori concursus the COMI? And thanks to the unification of the member state registries, information will be freely available. And that's going to be key for the safety of the business, for the fact that anyone who has interest, not a legal interest, but who is interested in getting information, would be in a position to see and check whether any business in any other member state is covered by proceedings, who are the administrators or who are the IPs involved. What type of proceedings, what is the stage of the proceeding, what rulings have been issued. That's, I think, a fundamental improvement, and hopefully the timeline presented, as you can see on the slide, will be followed. So moving on now to the key elements, really what are the pre-insolvency proceedings, what is the meaning and what is the scope. And it follows from what has been already covered in the previous session. We don't have, there is no definition as such of insolvency proceedings in a recast, and so there is also no definition of what is a preventive proceeding. It's all left to the member state to decide. The bottom line is, at the end of the day, is that these proceedings need to fulfill the requirements on the definition of this, the provision which deals with the scope, and also, as you will see, in terms of access, one needs to just look at the annex, whether they are listed in the annex or not. One of the key elements, and since I come from a country which has implemented recently, that is in January of 2016, a totally new preventive law which prevents against insolvency. We have experienced now after 1 year. But the key point here is that when you look at the definition which is proposed by the Polish restructuring law, because it's called restructuring law, you will see that the aims of the provision within the scope is met. In other words, the restructuring law in Poland is aimed at avoidance of liquidation, insolvency. There is one type of proceeding which allows the business to be reorganized or restructured before an arrangement is being accepted. Well, nothing happens. Okay, so to come really to the most important part. Article 1 of the regulation defines what falls within the scope, and I think one should read this article very carefully, because almost each word has a meaning, and I will try to go through these in a broad manner. So it applies to public collective proceedings, including interim proceedings. You should follow the explanation in the preamble, but obviously public means that they are not private proceedings, even though part of the proceeding can be private. And the reason why they are private is quite obvious. It's for economic terms. It's to keep the business viable, because not everyone needs to know about the fact that a proceeding has been opened. And of course, this will create some problems for interpretation, and for putting on the list with the type of proceedings which exists in some of the member states to be included within this sort of within the scope of the preventive proceedings, so that they are collective, meaning that they should relate to all creditors, but they do not have to be all creditors. There can be certain types or group of creditors. They are based on laws relating to insolvency, which implies a contrario, that they cannot be based on any other laws, meaning that the aim of the proceeding as regulated on the national law is to avoid at some stage the insolvency as such, because the law defines the insolvency, and not to reach any other means. The best example is that you may have restructuring proceedings under company law, and obviously they will not fulfill this requirement. So even if we have at the end of Article 1 what is meant by related to insolvency, and so it's a loose relation, it's a likelihood of insolvency. So the insolvency may come in the future, it doesn't have to come, but there's a risk of insolvency. And the aims of this proceedings, it's the avoidance of insolvency, cessation of conduct of business. By that I mean a formal cessation, usually which is related for entities which are registered in the registries. They are deleted from these registries. And obviously, more an economic term, so that the debtor's business may be continued, or the debtor's business may be terminated, and that by that one can differentiate between the termination of existence of the entity with the transfer of the business, for example, as a result of a mentioned already prepackaged sale. So, and these preventive proceedings need to have a specific aim. So we have covered the rescue. There's also the adjustment of debt. Although it's to me, I think it sounds a little bit funny because it's usually a decrease of debt rather than just an adjustment. So that's a very polite term. But of course, we may have situations that some creditors increase the debt, but this would not be a debt which arose before the opening of the proceedings. Reorganization implies, of course, that usually, in order to use assets, they need to be used more efficiently. Otherwise, this may have been the reason in the first place of the problems. So some of the non-core assets of a business may be disposed of, sold to improve liquidity, for example, or unfortunately the organization may also relate to reorganization of the human workforce, which is also maybe unhuman to use this term in relation to humans, or it can lead to liquidation, of course, which can also be part of a reorganization proceeding or preventive proceeding. What this implies also that there are certain, if you like, elements which are key in these preventive proceedings, and one of the key elements is that the debtor needs to be totally or partially divested of its assets. To me, it means that a debtor needs to lose control over the management of its assets, either totally or partially. In practice, it implies that the debtor, depending on the type of provision, stays in possession, or there's a court supervisor, or there is someone who needs to provide the consent, and in many jurisdictions the powers are divided between those which are day-to-day management, ordinary management, some jurisdictions would say, and those powers which go for the non-day-to-day decisions or disposal or liabilities which need to be taken by the debtor, and for that one needs to have a consent of the supervisor, which may be court nominated. Another element, and this is, I think, the heart of the matter, and this is and probably will be a heart of this, also of any disputes related to preventive proceedings, is the subject to control or supervision by a court. Again, the terminology used, control or supervision, of course, one has a wider probably meaning, because supervision may imply that you have certain powers over the assets and affairs of the debtor. But I think in practice it means that depending on the national law, and please remember that the language used by the recast is one which should be understood by all of the national experts. So I would think that the issue here is that the court needs to be involved either at the beginning. Of course, with preventive proceeding, this doesn't have to be the beginning, but must play a certain role. For example, clearly it must approve the arrangement plan that is accepted, clearly must be able to deal with objections to the arrangement submitted by creditors, clearly must look at the rights of creditors, must look at whether the provisions of law have been applied as regulated. So the involvement of the court is I think, one of the key elements of a pre-insolvency proceeding, but also I presume that this will be also subject to certain controversies. There's the definition of the court for different situations. Now, another element which is built into any restructuring is a temporary stay of enforcement actions. The stay, of course, is fundamental to the success of any restructuring. Without a stay, It goes without saying that some key elements of the business, and we've touched, Stefania mentioned the rights in rem. This is also a room for controversy to what extent one should comply with the rights in rem and allow a debtor to enforce its rights to be satisfied on the basis of dura rex sed lex or pacta sunt servanda, and to what extent you have to account for the interest of the debtor and allow restructuring. And clearly with this provision you should allow a temporary stay under either treated individually or by law, so that the aims of the restructuring can be achieved, meaning that one needs to monitor, meaning the court needs to monitor to what extent the stay is required, because on the other side of the coin you have the rights of the creditor who needs to enforce the rights. So I think this is a very sensitive element, but one which is essential for the success of the restructuring. This is more of a formal one. Section 2 of Article 1 deals with entities to which the regulation would not apply. This deals with insurance, credit institutions, investment funds, and collective investment undertakings. Now, the second term used in the title of my presentation, which I felt a duty to deal with, is the term, I don't know how to pronounce that. Is it hybrid or hybrid? We all know what a hybrid is. It's a car which has two engines, one petrol, one electric. So I think we know what we're talking about. They are, as in a car, they have to cooperate with each other in the hybrid. So it's all about efficiency. And I think hybrid proceedings are also about efficiency, maybe not only about efficiency, but hybrid proceedings are something in between the formal proceedings. Formal proceedings where typically or traditionally you open the proceedings, the debtor opens the proceedings or the creditor. There's a court involved. There may be some provisional measures of the assets so that the assets are retained for creditors. And on the other hand, each member state and also in cross-border transactions, we all know how difficult it was to have an out-of-court restructuring which was regulated by provisions of civil law, where in order to reach some sort of arrangement, initial even arrangement, first of all, one had to deal with what the law should be dealing with, that is the stay of enforcement. So in many jurisdictions, the concept of signing standstill agreements evolved, and each of us has probably experiences in spending nights and trying to persuade one of the last key creditors, financial creditors, to sign a standstill agreement before one can deal with the restructuring of assets and really with the key essence of restructuring, with intercreditor agreements, with settlement of outstanding debt. So in order to avoid all this, we have these hybrid proceedings which are in the middle, which means that there may be, this is not a condition, but there may be a private part of the proceeding where the debtor talks only to some limited number of creditors which are key. Then at a later stage, obviously, the proceeding needs to be made public, and it needs to apply to all those who are affected by this type of proceeding. And as is the case with, in terms of ranking of proceedings, I would think that hybrid proceedings are one of the types of preventive proceedings. So in terms of ingredients of the proceedings which are hybrid, they need to fill in the requirements set by Article 1. I've mentioned already a couple of elements of a hybrid, but clearly the right to vote by an affected creditor is key to vote over the arrangement. The hybrid proceeding should, in my view, also be regulated by law, and to this end, the law should regulate when an arrangement can be voted by stakeholders, not necessarily just creditors, but stakeholders. When the plan is accepted, there needs to be a specific majority for the arrangement to be binding. And this goes to the last point on this list, that it needs to affect erga omnes, but not erga omnes everyone, but those who are affected, those who are participating in the proceedings. There need to be a right to challenge the place where the proceedings have been opened, to appeal the arrangement. These are similar elements as found in a typical preventive proceeding. So to put it simply, a hybrid proceeding is one which is in the annex, or will be in the annex rather, because if I look at proceedings which are listed in the annex currently in relation to Poland, I see that not only the last proceedings, the restructuring proceedings which have been introduced in January 2016, but also when we had the previous reform, the previous proceeding which was there was also not listed. So, theory and practice are two things, and therefore one may face a nasty surprise depending on where you come from. Another interesting, and this is a specific case of a Spanish company. I just wanted to go quickly through some of the issues which were raised and which may be an example of the type of questions which are raised in case you have to apply a hybrid proceeding. And this is obviously was not a case related to the new regulation, to the recast, but some typical issues were subject of if like dispute. So what was at stake was whether the proceedings which were opened in relation to Abogea, which is a Spanish company, and which were at the end of the day, I understand, recognized in the US under Chapter 15 proceedings, whether they were collective proceedings and therefore they should be recognized or they should not be recognized. And here on the example of two proceedings, for example, the Sauvegarde Financière Accélérée, or there's a Polish proceeding which deals with certain type of creditors, it means that being collective doesn't have to cover all of the creditors, but may cover a certain type or group of creditors. It requires supervision. I have mentioned that it requires supervision of the court. There's no doubt about it, but it doesn't have to be from the very start. It requires divestment. The court needs to also check the fairness of the deal at the end of the day. The application, for example, what is very sensitive of cram down or cross cram down across the class procedures. So where are we heading? I think we are heading to a much more complex world, and I think the initiative which will be also taken by the IP holders will be key to the success of any restructuring proceeding. I think we'll still need plenty of time to learn how the regulation is or will be applied in practice, and the invention of advisors is there to be applied. The world will become much more complex after the 26th of June, and on the other hand, the simplicity that law should be applied by every participant, every debtor, every creditor, I think has reached a new stage that they need advisors, and the role of the advisors is has been slightly taken over by IP practitioners and will be on the rise. I think this profession will evolve around Europe. Thank you very much, Michael and everyone. I'm open to questions if we have time.